and we'll be live in just a few seconds.
Looks like we're good.
We're good.
Okay, thank you, Wendy. Bang, bang. I'm officially calling the February 25th, 2021 public hearing of the Executive and Legislative Nominations Committee to order. It is 10:07. The House Chair, Joe Gresco, thank you for joining us this morning. As you know, our committee interviews nominees as a form of checks and balances. And our nominees will be allowed to give a introductory statement very shortly. Our agenda has a single candidate for Claims Commissioner today, nominated by Governor Lamont. Congratulations, Christy, on your renomination.
Thank you.
So all else fails, unless I have a comment from my co-chair, we're good to go. So the House Joint Resolution reconfirming Christy Scott of Berlin as Claims Commissioner. Christy, we have one item to do before we let you have your opening statement. Will you please raise your right hand into the screen so we can see it? Do you promise, swear, or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Great. The floor is yours, ma'am.
Thank you. Good morning, Senator Duff, Representative Gresco, Senator Kelly, Representative Kennedy, and members of the committee. My name is Christy Scott, as Representative Gresco just told you, and it is an honor to appear before you as Governor Lamont's nominee for reappointment to the position of Claims Commissioner. When I appeared before this committee for my initial nomination, I committed to an efficient, timely, and transparent claims process. I am confident that we have achieved our goals of an efficient and transparent process, although technology will soon improve our performance in both areas. I'm disappointed to admit that we have not yet achieved the goal of a timely process, primarily because of my battle with a disabling health condition, which I'm going to discuss further later. But first, let me discuss some of our accomplishments. I'm pleased that we implemented all of the following. We simplified all of our forms and templates and are now using non-technical language so that we can be more accessible to all of our claimants, many of whom are inmates or pro se claimants. We have done a head-to-toe overhaul of our website, including placing simplified fillable forms on the website for both new claims and our fee waiver applications. We placed detailed instructions on how to file a new claim, as well as easy to understand guidance about various aspects of the process, including what to expect at a hearing, what the statute of limitations means, what types of relief are available at the Claims Commissioner's office. And we placed links to statutes, regulations, and other useful resources on the website as well. We began electronic transmittal. Oh, I skipped some things. We shortened deadlines for all aspects of the process. When I came in, there were very long deadlines that had been set for various pieces of the process. I thought that seemed excessive, that if parties needed more time, they could ask for it, but let's shorten up these deadlines and create an expectation of a quicker process. So we did that. And we began electronic transmittal of new claims to the Attorney General's office so that they could file appearances more quickly and we could speed up the process in that way. We also began accepting pleadings by email. Which was new. We had previously expected a copy by fax or mail, and so email was a lot more convenient for most of our practitioners. And we finally developed and implemented a electronic case management system. When I first came into the office, our staff was tracking cases on paper. They were actually using a notebook to track cases in the motions and what have you. So we implemented a software program that allowed us to track everything electronically and has really improved our efficiency and transparency in the sense that we can respond to inquiries a lot more promptly and accurately. So during last piece, we also are almost ready to begin testing a public software program that's going to allow parties to file. I saw a question coming. No? Shall I keep going? Okay. We also are going to begin testing a public software program that's going to allow parties to file new claims electronically and all their pleadings electronically. And it will allow the public to view the status of claims and even do searches for documents and review documents online. So we expect this improvement to greatly improve our efficiency and the transparency of our process, because people will be able to look at documents without having to come down to our office to see them. So, so I'm very pleased about all of that. I think those are very significant changes that have made the office more efficient and more transparent, and we're just continuing with that, and there'll be more of that coming online as we move forward. There have been significant statutory changes that have happened since I was appointed initially. The legislature has passed two significant bills. One was Public Act 16-127, and its highlights were that it authorized the office to use magistrates to help resolve claims, and it required the exhaustion of remedies for inmates before they could bring a claim. It also significantly rewrote the wrongful incarceration statute. And then Public Act 19-182 increased the maximum amount that the claims commissioner could make award to parties from $20,000 to $35,000. So it allows the claims commissioner to resolve more claims without them having to go to court or to come to the legislature. And it increased the amount for legislative appeals from $20,000 to $50,000. It also allowed medical malpractice claims to be filed directly in Superior Court, which I think is more efficient for them, because what was happening is that if they satisfied the requirements for Superior Court, the claims commissioner was required to send them to Superior Court. So she was really just kind of a way station for something that was already going to end up there anyway. It made a lot of sense to just let them go straight there and let the Superior Court judges bump them out if they didn't satisfy those requirements. So I would like to discuss further the use of magistrates. I am extremely grateful to the legislature for authorizing the use of magistrates to help with our caseload and to fund us with a lump sum of money that we have been using over the course of several years, because they've been authorizing our carry forward, and that's been great. But the reason we haven't used all that money in one fell swoop was largely because of the nature of the way magistrates can be used. These are they are very professional, hardworking lawyers. We've had a real privilege to work with them. They've been a great resource for me because I can talk to them. They're another set of ears that I can talk to about legal issues, and that they've been great to have on board. But they are all independent lawyers with an independent practice, and their availability is limited. They're not available full-time to me. And it's been a relief to have them available to handle hearings and other work on an occasional basis. But they are not a substitute for a full-time entry-level staff attorney, which is what I believe the office really needs in order to function properly. And I've said that before. This is not a new recommendation. The commissioner's workload involves a fair amount of work that is fairly routine and straightforward, like motions to dismiss for lack of subject matter jurisdiction, which I get many of. And that work needs to be done by a lawyer, but it doesn't necessarily need to be done by a very experienced lawyer. And then the office has more complicated work that does require the attention of an experienced lawyer. If I had a staff attorney who could be tasked with these more routine matters and could be freed up for the work that requires an experienced eye, the improvement in the efficiency and timeliness of the office's work would be exponential. So next, let's discuss the obstacles the office has faced. As I just mentioned, one of the office's ongoing obstacles, which predates me, predates the former commissioner, it's been an issue for the office for many years, is the lack of resources. We currently operate with one paralegal and a half-time processing technician. The addition of one entry-level staff attorney would make a significant difference to our little team. Like most agencies, we've been impacted by the challenges brought by the pandemic. As a small agency housed within a large agency for administrative purposes only, we struggle when either of our two staff members misses work or loses productivity for any reason. And I don't say that in any way to disparage the support we receive from DAS. They are wonderful. They give us great business office support and human resources support, but they aren't there to provide us with staffing support. That's not what they do. And so when we do have a staffing issue, we just have to be creative, get creative and do what we can to try to fill that gap, because we don't really have a support, a net, right? We don't have a safety net for that situation. The changes imposed by the pandemic threaten to make our precarious situation that much worse. But we made creative arrangements and have kept the work of the office moving along. And I'm fairly proud of that my staff was willing to be flexible, and we all worked together and took on different roles than we had previously had, and we kept it going. So I'm very proud of that. Unfortunately, a significant obstacle to the office's work has been my health issues. I suffered an extended period of disabling bouts of a health problem that reduced my productivity and required me to take sick leave at times. A number of you on this committee know me from my time working here at the legislature, and you may remember me as someone who typically had her head down in her computer in the midst of whatever chaos or whatever late hour we were all experiencing. I've always prided myself on that trait, that I am focused and hardworking, and that I succeed at tasks that I undertake. I have been extremely frustrated by my inability to be that person and disappointed as I watched myself fail to meet my own standards for myself. I have not been able to improve the office's timely resolution of claims, and claimants have been kept waiting longer than is acceptable because of my health problems. And I deeply regret that. And I would like to apologize to each and every one of them. And in fact, I have apologized to many of them over the course of handling their claims. After much experimentation with medicines and other treatments, my doctor and I finally seem to have found an approach that allows me to work like my old self. And I have, while I'm probably not ready to draft amendments at 3 a.m. just yet, like I used to do, fortunately, that's not within the Claims Commissioner's job description. So I will say, though, in all seriousness, if I were not improved enough to be able to work normally and be fully productive again, I would not have accepted the governor's nomination. I have felt too much distress about how my health has impacted claimants to want to put myself or them through that again. So that said, I don't want to exaggerate the impact of my health on the work of the office. The work of the office has not been at a standstill. We have continued to process and dispose of claims, and our backlog, although somewhat larger than the one I inherited, is not egregiously larger. It is not insurmountable. As you may know, there has always been a backlog at that office. It predates me, it predates Commissioner Vance. That the office has been chronically under-resourced and has had a chronic backlog. And that is a problem that I think commissioners have struggled to know how to resolve. And that we still, I think, have to figure out how to resolve. In addition, we've had another little wrinkle over the past couple of years, which is that the claims that we send to the legislature each year for review were not sent back to us in 2019 and 2020. Which prevented us from resolving those particular claims. It's about 200 claims, and then we sent another 80 this year. So we're right now have about just shy of 300 of our claims sitting at the legislature. We are optimistic that we will get those claims back this summer. We've been told by the judiciary chairs that that's a priority for them. So fingers crossed we'll get those back, and we will be able to tackle them as soon as possible, knowing that those claimants must be particularly frustrated to have been put on hold for longer than they expected. So thank you for your attention, and I am ready to answer your questions.
Thank you, Chris. Thank you, Commissioner Scott. How are you feeling today? That's what
I'm feeling marvelous today. I'm actually really happy to be here. It's been a long while since I've seen many of my friends' faces, and it's been a long while that I've been in the job and been wanting to have an opportunity to talk about the work we've been doing and the issues that we faced.
We're all glad that you're feeling better, and I'm not an attorney, so I'm going to leave the technical questions to the members. But one question that interests me, and maybe you can tell us what you would classify your style as, whether or not you felt you were neutral, or were you put in that position to, defend the state from these lawsuits.
I don't think that I'm either, actually. So as I see the role, the legislature constitutionally has the power to decide whether it should waive its sovereign immunity. When somebody comes to the state and says, state, you injured me in the course of your activities, and you should compensate me for that. You should give me money because you hurt me. The legislature is the body that decides whether or not to compensate that person, whether to waive its sovereign immunity. And over time, that burden became too heavy for the legislature. So it delegated that responsibility to various entities. And over time, that entity became the claims commissioner. So it's my job to just exercise the legislature's duty to waive its sovereign immunity, but I do that according to its instructions. And the instructions the legislature has given me are in the statutes. So what I see as my role is to read the statutes and do what the legislature's told me to do. And so I think in terms of who does that favor, is it the state or is it the claimant or what's the role? I think the statutes strike a balance, attempt to strike a balance between protecting the state's resources and the public fisc and recognizing when people who've been injured have a just claim that should be paid. And the statutes strike that balance in a particular way. And it's just my job to sort of read the statutes and do what they've told me to do and strike that balance the way the statutes have said to strike it. So that's kind of the way I see the role. Does that make sense?
Thank you. And I have one more question, and then I will be turning it over to my Senate co-chair. But in the meantime, if members do have questions, if you can raise your hand in the Zoom link, we will start the queue for that. But my other question was, currently there is a proposed bill, House Bill 6506, and so I'm accurate. It's revising procedures of the Office of the Claims Commissioner, including authorizing claimants to file a certificate of merit, allowing you to grant permission to sue the state without a hearing, and providing that certain claims have time limits, or they are deemed granted permission to sue the state. Your idea, or do you support it?
Yeah, it wasn't my idea, but I have had conversations with some folks who I think the ideas originally came from, or at least who like the idea. What I'll say about it is that I don't have any objections to it. I see no harm to the office from it. I think that it would certainly, from an office point of view, it would help us clear out our backlog. It would do that. I think from a public policy point of view, what I would say is it would balance the roles I was talking about, the protecting the state's resources versus making sure claimants get compensated for injury. It would strike the balance differently than is currently struck by the statutes. And that's a public policy decision the legislature has to make. It would mean that more people would get paid than are currently being paid, I think, because it would mean less vetting by the claims commissioner, right? Things would just go with less thorough review by the claims commissioner. I don't know that that's a bad thing. It's just a different balancing. And they would still get vetted by the Superior Court judges. So it's not like they wouldn't still be reviewed by a perfectly competent adjudicator. But it would mean that the Attorney General's office would need to defend them in court. But they wouldn't be defending them at a hearing before a claims commissioner. So, you can argue that maybe it's not that much of an extra burden on the state's resources, and that you still have a Superior Court judge deciding what the merits are anyway. It would definitely clear out our backlog, so it would be, beneficial to the office in that way. So I have no objection to it from the point of view of impact on the office, and to the extent that it represents a different kind of balancing of the state's interests. I say that's a public policy decision for the legislature, and I'm happy to do whatever the legislature tells me is its will. So is that helpful?
Very much so, Christy. Thank you for the answer. Next, we're going to go to my Senate co-chair, Senator Duff. The floor is yours, sir.
Thank you, Mr. Chairman. I appreciate that. And good morning again, everybody. Good morning, Christy. Good to see you. Appreciate it. Thank you for your testimony. Representative Gresko actually asked the kind of the million-dollar question about the bill that's out there right now, because I think which predates even you, is there's been frustration at the fact of many of these cases that have been backlogged for such a long time, and it really does inhibit people from getting their day in court and being able to get compensated if in fact that's, they should be compensated.
Yes.
Many people now have waited a very long time. So can you just share with me how, as far as the backlog goes, what is longest, what is the oldest backlog, I guess, or the oldest case that's out there? How many years?
Oh, well, that's a really good question. I wasn't expecting that one, but I do think I have the information. I just probably behind my computer.
And you can get it to me later. That's fine. I mean, would you say it's more than 5 years?
Oh, yeah, I do think we have, but one thing you have to bear in mind is that some of the really old cases we have are sometimes pending for, it's not always because the claims commissioner just hasn't done its job. Sometimes the cases are pending because they were on stay for an extended period of time because the parties asked for them to be on stay. So it's not always, you can't just say, oh, there's been a case there since 2015. Isn't that terrible? It's often more complicated than that. But I think, I can't tell you with 100% certainty without checking with our office paralegal. I think our oldest case is probably 2015. But I again would have to give you the caveat that
I didn't mean to stump you.
No, that's okay. I wasn't expecting that one. But I think it may be 2015.
How many?
I think it may be 2015. The oldest.
Okay, 2015. Okay, no, that's good to know. So I think that, it just, as we debate that bill, that helps us to kind of formulate whether or not that's a policy we want to move forward on. If a case has been lingering for 6 years, and that means that it's, probably longer than that even, because it gets to you when it gets to you. So
and I'll find out for you, and I'll look at the oldest cases and find out if there's a reason why they're there, and that's beyond just the claims commissioner's been overwhelmed, and because the oldest cases, I suspect there's some reason that they're still here, because there's not very many of them that are, so, but I can maybe give you a sense of where the line is, where there's a bunch of cases that are still there that are just hanging around because we've been overwhelmed. And I can
and right, and for context point, that probably makes more sense than even what's the oldest case. So I appreciate that very much. And so again, as we kind of debate that bill, I think it's important to kind of know, because you don't want to have where people don't have the ability to have justice. And it's not, and again, you inherited a backlog. There's a backlog before that. There's a staffing issue, obviously. So I think, as you come before this committee, we can vet that out a little bit to try and find solutions that we can talk to our colleagues about as well.
Another piece just to add in there, which I haven't previously talked about very much, but we also have seen a surge in the number of claims being filed every year. So we had we typically, as I understand it, in past years, it's varied around 400-ish, give or take a bit. We had 493 in 2018, 626 in 2019, 523 in 2020.
Yeah.
And then it would go down for our COVID year, our 2021 report, which was the 2020 year. But we've seen, and the number of claims just keeps going up and up. So, that doesn't help with the problem, the ongoing backlog when the volume is going up on the front side. So.
Great. Yeah, no, I hear you. And I would say, the provisions we put in to help, I think, have getting you some additional, was judge trial referees, did you say?
The magistrates, they come
magistrate,
off of,
that's right.
Yeah, they come off of the small claims and motor vehicle list in the judiciary. And then they work as magistrates for us. And they've been helpful, but like I said, they're not, as available. They don't sit in the office, and I don't teach them how I handle a certain piece of the work, and then they go to town on all those cases. That's not the way it works, which is what would be really helpful, right? To be able to say, hey, here's all these motions to dismiss. Here's how I handle them. Go crazy. And instead, I'll have a hearing this week. Oh, I'm really trying to get this big case out. Can you find a magistrate to handle it? And that's how they've been helpful, which is great, but it doesn't take enough burden off to really, feel as impactful as a full-time staff attorney would,
Okay,
so.
Great. I appreciate it. Thank you, Christy. Thanks for your answers. Thank you, Ms. Chair.
Thank you.
Thank you, Senator. Next, we're going to go to Senator Looney, our Senate President, with some questions. Sir, the floor is yours.
Thank you. Thank you, Mr. Chairman. And congratulations, Christy, on your renomination. And great to see you today.
Nice to see you. Thank you.
Great to see you. A couple of questions. Would you recommend any statutory changes to the General Assembly this year, other than the budget change of adding a full-time staff attorney to the office, as you mentioned earlier? Are there any other things that you would recommend to us as legislation this year?
Well, I have had some conversations with some of the claimant side attorneys who've appeared before us about whether I should have more flexibility to waive hearings. And take on cases just on documentary evidence. Right now, the statute only allows me to waive hearings if the claim is of $10,000 or less. And I think that there's an argument to be made that perhaps the claims commissioner should have the discretion to waive a hearing in any case if she thinks it's amenable to it, or at least that the amount should be higher at the very least, because some cases really don't necessarily need a full evidentiary hearing with witnesses and cross-examination and what have you. So that's one conversation that we've had, and that I would be interested in seeing some modification, perhaps a little bit more flexibility to dispose of evidentiary hearings in more cases, if they can be handled on just with documentary evidence. But other than that, I think a lot of the changes that have already been made in the last few years have been helpful, and that we should be able to do what we need to do. It would be nice to have more resources, but other than that, I think we can work with the statutes that we've got pretty effectively. Yeah.
Good. I had another question. Do you think that there are there any other categories of claims that you handle right now that you think it would be more efficient to allow them to go directly to Superior Court? And in other words, are there any other areas where you don't think the issue of sovereign immunity should apply to require these cases to be routed to the claims commissioner? Are there any other cases where you think direct action would be appropriate, where the state is the defendant?
Oh, that's an interesting question. Well, I think there's a strong argument to be made for some of our wrongful death cases, that if I have to decide whether permission to sue should be granted, they're just very evidence intensive, right? There's big dollar amounts, and the state is going to really want to do extensive discovery before and fight it pretty hard at our level, which means that if I do grant permission to sue, then it's a double trial, if you will. And that doesn't seem very efficient. And so perhaps some of those wrongful death cases, because it's a similar type of situation like the medical malpractice, where it's a lot of money, it's a very high stakes case, and it doesn't seem efficient to make the case, the parties sort of try it twice. But maybe those might be amenable to being sent along with, if we had, a good faith certificate and some documentary evidence and well-pled document, that sort of thing.
Right.
So something like that.
I was thinking, those, as you say, those are going to be intensive in terms of process at your level, and then it's replicated all over again at the Superior Court level should it go to trial, and lengthening the whole process greatly. Right. Obviously we have in cases where there's motor vehicle accidents, the sole proximate cause standard, where if there's any other contributing factor, the state is let out as a defendant in those cases. But are there any other cases where you think we should have that standard? In other words, what we have in the motor vehicle cases, where if there's any element of contributory negligence, the state is out, or if there's evidence of a third party other than the state being partially responsible, the state is out altogether. Do you think, are there any other situations like that we should extend the sole proximate cause standard to?
It's like back in law school.
Well, Senator Looney is actually raising a really interesting question, because the statute, Senator Looney, currently says 4-142 A 2 says that claims upon which suit otherwise is authorized by law, including suits to recover similar relief arising from the same set of facts, are accepted from the claims commissioner's jurisdiction.
Mm-hmm.
And this is a very interesting question you're raising, because as best as I can determine, because there's no real body of law at the claims commissioner's office, there's no real way to research precedent, and no claims commissioner is bound by another claims commissioner.
Right.
So it's very difficult to sort of ascertain case law, if you will. But to the extent I can determine what past claims commissioners have done, it appears that how they've interpreted that provision is that if a claim can be brought against the state in another forum, then you dismiss the case for lack of subject matter jurisdiction. So if you have a 1983 action in federal court, you dismiss the case.
Right.
If the claim can be brought against a state employee under 4-165, because the state employee's actions were wanton, reckless, or malicious, and therefore they don't have state immunity anymore, then you have to sue the state employee and you dismiss for lack of subject matter jurisdiction.
Right. So the claims commission doesn't get involved then, right? Yeah.
Right.
Right.
But if you can sue a third party who's not a state actor,
right,
and the question then is, well, then should you also dismiss it against the state because you can sue this third party?
right.
And claims commissioners have not dismissed those cases.
I see.
They have held those cases. What they have tended to do is stay the claims commissioner action pending resolution of the third party action, and then allow this claims commissioner action to move forward, as best as I understand it, with an offset for whatever remedy, whatever relief may have been granted in the third party action. So, but I'm not quite sure how that reconciles with the language of 4-142A2. So your question is calling up for me that legal issue that I have not fully resolved in my mind yet about whether the state's even on the hook when there's a third party that can also be on the hook.
Maybe we should ask the Judiciary Committee just to take a look at that. And
it's just an interesting question in my mind, right?
Yes.
So, but if we presume that there is a third party on the hook and that the state can also be on the hook at the same time, then your question is an interesting one. Is there any category where we should say no? If there's a third party on the hook, then the state's not on the hook.
Right.
And I hadn't really thought about that particular subset of that question. I hadn't thought about it truthfully. Perhaps it should. There should be when there's a third party who has engaged in criminal activity. Perhaps. Maybe. I'm not sure though. Yeah. So
good. Yeah. Good. I appreciate it. Yeah. That is, I think, could be something
I will give it a thought.
That the committee could look at.
I will give it a thought.
Good. Good. And just one other question. You mentioned there's been an increase in the number of cases every year. It seems there are more cases filed. Has there been an increase in any particular category? Are you getting more claims from prison inmates, or is there any pattern to where the increase is coming from?
I haven't asked our paralegal to research that question, but from just a gut based on what I've seen coming across my desk, I would say we've had a significant increase in inmate claims.
Now that's interesting because we've seen a decline in the inmate population substantially over the years. It's now about half of what it was at its peak. We're now under 10,000 inmates when we were over 20,000. So it seems we have more litigious inmates still within.
Yes, and we created an exhaustion requirement, so we should have fewer. And maybe I'm wrong about that. That could just be. It's a very much a subjective answer I'm giving you, so I could be wrong. And I can ask Tara to actually look at that question, and we'll get you actual objective information.
Yeah, I would like to see that because I know there are some inmates who are litigation factories in and of themselves. They have many habeas claims pending, and I assume maybe many claims commission issues pending as well. So sometimes it doesn't take a lot of inmates to create a large number of cases. And,
we do have some frequent flyers for sure.
Yeah, that's what I kind of expected because the same is true in the habeas category with the AG's office dealing with those. Yeah. And well, good. That was the only questions I had. I wanted to just thank you again for your service and look forward to your continued work on behalf of the state.
Thank you so much. Thank you.
Good, good.
Thank you, Senator. Thank you for the education. And next with questions is our House Ranking Member, Representative Kennedy. Ma'am, the floor is yours.
Thank you, Mr. Chairman, and good morning, Commissioner Scott. Welcome. It's
Thank you.
good to have you here, and congratulations on your renomination. I don't have it in front of me. When were you first nominated to serve as Commissioner of the Claims?
I was confirmed in March of 2016.
Okay, and just following up a little on some of Senator Looney's questions. How many claims are currently pending with the commission
Well,
right now?
We have, I did pull this number. We have, if you subtract the number that are pending at the legislature, we have 767 pending, but there are 276 currently at the legislature.
Okay, and following along that, you had mentioned in your testimony that you implemented an electronic case management system. Does that help you to track the cases, what types of cases are coming in, so that, like Senator Looney had asked, where the number of cases kind of comes from? You said possibly inmate, the most increases in inmate. Does the case management system break those down so that you're able to see what cases are and where they're coming from? Does that help?
Yes, it will allow us, we do track if the claimants are inmates or if they're self-represented. And we also track the category of claim. Is it a personal injury? Is it a contract breach? Is it a, I'm trying to think of the different categories that we have, but we've broken them down by various typical types of claims that we get as well.
Oh, okay, thank you. And you had mentioned Senator Duff had asked about one of the oldest claims, and you said it dated back to approximately 2016. Are there a number of other cases that go back that far? A lot.
I think 2015, and I think we may have less than a handful that are, 3 or 4 that are 2015. But I'm just guessing based on my last time I was in our. So we have a legacy database and we have our new database. And I was in the legacy database a few days ago looking for something, and I think I recall that the oldest ones I saw there were a few 2015s, but I could be misremembering. So I need to ask my paralegal to actually go and do a accurate review to make sure that I'm correct. So I'm just, please don't hold me to it. It's just based on what I think I saw last time I was in our legacy database. So.
And you had mentioned your illness, and I'm so sorry that you went through it. I can emphasize with that, but you seem to be on your game right now, and that's awesome. I'm glad for you.
I'm doing much better. So, thank you. It's such a relief. Yeah. Such a relief.
And on that same note, so unfortunately, when you were ill, who picked up the slack? Who would do the cases? Who did your workload when you were unavailable? Would it be your paralegal? Because you only have magistrates that help out here and there, but who was able to pick up on those cases during that time?
So that is, I think, a real flaw, if you will, in the structure of the office. There's nobody to pick up anybody's slack. There's one claims commissioner, there's one paralegal, there's one processing technician. We don't have a safety net. And so what we did was that I did the work that needed to be done to keep the office moving along. I did findings and orders. I did withdrawals. I did, I handled motions to the best of my ability. But the things that didn't get done were the things that were the most taxing, right? I didn't handle new hearings. I didn't take on new hearings. I didn't write demanding memoranda of decision. Those all things sort of sat by the wayside because they required too much screen time. One of the things I couldn't do was look at screens very long. Those things that were just too hard on me just didn't get done. And that's why a lot of stuff didn't get dealt with that needed to get dealt with. But I did try to handle the essential stuff, kept the wheels rolling, right? The things that kept cases moving forward. except for that final resolution question. Decisions largely didn't get written because that was just too demanding. But the other stuff I did try to keep moving forward.
And I appreciate it. And thank you so much for that. Mr. Chair, I just have two more questions. How do you determine what case is it? Is it what comes in first? Is it what's already back there? How do you make the determination of which cases to proceed with?
In terms of like what motions to dismiss to handle or what case to schedule for hearing or, okay, so the cases to schedule for hearing, our paralegal, Tara, she really handles the case flow questions. And when she's the one who's, when a pleading comes in, she's the one who's docketing it and doing the, making sure the next thing that's supposed to happen happens. And when we come to the point where right before a case is ready for a hearing, we ask the parties to submit something called a predisposition memorandum. It's like a pretrial memo that you would file in Superior Court that just basically says, here's what we expect to happen at the hearing. And we have both of those PDMs that have been filed. The case is now ready for a hearing, and Tara will send out an order scheduling it for a hearing. So it's really Tara who says, okay, this case is ready for a hearing now. And what she'll typically do when she sets a date for the hearing is she shoots a notice over to me that, hey, I'm scheduling this for a hearing on this day, and I accept it. If I don't accept it or I have a problem with it, then she'll find a magistrate if she can. And if she can't find a magistrate, she'll reschedule it for another day, and then she sends out the order to the parties and goes from there. So she's really the one who says, this case is ready, let's schedule it.
Gotcha.
And so she's the one who's keeping track of that sort of thing. And so the same thing with motions to dismiss. If a motion to dismiss comes in, she's the one who puts it in front of me. Whether it's in our electronic database, she can put it in my queue, or if it's something that comes in a hard file, she puts the hard file on my desk and with the motion on top saying, hey, this is ready for you to work on. So,
and just one last question. So, and as you were saying, a lot of your cases, the increases through inmates. And so there are probably a lot of pretty much pro se cases. So they're doing the best to follow in accordance with the law. And I would imagine some of those respectfully are somewhat frivolous. Are those somehow weeded out so that those cases don't get bogged down, or that so that you can proceed to the cases that, like you were saying, get those ready to process through? How is that dealt with?
Yeah, so there's two ways that we try to hit those pretty quickly. One way is that when most inmates seek a fee waiver, and when the fee waiver application, it comes to me, I always review the claim before I look at the fee waiver application. And I don't read it, carefully, but I read it, I skim it, more than skim it, but not read it in detail, if that makes sense. And I carefully skim it, and I look for a clear jurisdictional problem. And if I see a clear jurisdictional problem, which usually is that they're alleging a civil rights violation, which doesn't belong with us, it belongs in federal court, I will create a note in the file, which we do all this in our electronic database. I create a note that says, notice of possible dismissal, which is a document that I created when I first came there, which is a notice that we send out to the parties saying, this case may be dismissed for lack of subject matter jurisdiction. Please submit a brief by this date if you wish to do so. You're on notice. And I tell them why. I don't just say subject matter jurisdiction. I say because it alleges a civil rights action that can be heard in federal court, pursuant to 4-142A2, whatever. And so then that note goes into the file. And as soon as this AG's position statement comes in, if they haven't raised the jurisdictional issue, which they frequently do too, then our notice will go out. But if the other thing we did with the AG's office is that they asked for my permission, and I granted it, for them to create a form letter, a form document, which lists various grounds for dismissal, subject matter dismissal, with little check boxes next to it. And they said, would it be okay if we just check off a particular ground for dismissal and just use that as our motion for dismissal for these, repeat issues? And I said, yes. So now when they're supposed to file a position statement, often we'll just get this form motion to dismiss that checks off the box that they think is applicable. And we then say to the other side, hey, you have X amount of days to respond to this, and then we can dismiss it on that ground if it's meritorious. So those are the two different ways it can be dealt with pretty quickly, is that I either issue a notice of possible dismissal, or the AG's office uses their form checkbox, and we get rid of it pretty fast. So
Thank you so much.
Yeah, in an ideal world, that's what happens.
Thank you so much, Commissioner Scott, for answering all the questions, and I wish you the best, and please stay healthy. Thank you.
Thank you so much.
Thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Next to ask some questions is our House Vice Chair of the committee, Representative Quinn. Sir, the floor is yours.
Thank you, Mr. Chairman, and thank you, Commissioner Scott, for your willingness to continue in this job. You talked about potential increases in staff and adding a staff attorney. Is that going to solve your problems, or ideally, what would your office be staffed with?
I think that's ideally what the office would be staffed with, is a junior level lawyer who can keep those motions that need to be dealt with every day moving along and freeing up the commissioner to attend hearings and write decisions. That's the frustrating thing I found, is it's really hard to clear off my desk and make the time to write decisions, because every single day there's a pile of either discovery motions or usually it's motions to dismiss. And I felt that I owe the claimants some explanation of why I'm dismissing their case, even if it's just one paragraph. And I owe them at least one paragraph that says, I know what your claim is about. That it's not just this claim is dismissed. So I read your claim, I write, this claim is about this, one paragraph, and then I do some boilerplate that says, here's what our statutes say, and here's why, it's boilerplate, so I don't have to rewrite it every time. But it says, this is the statute that is the basis for my dismissing your claim. And then I have a paragraph that says, here's why I'm dismissing your claim, because you alleged a civil rights action, which satisfies this statute, and then I dismiss it. But that takes, 20 minutes to half an hour to do one of those, right? It's not a fast thing. So I can only do so many in the course of a day. And that could keep me busy all day long. We have so many motions to dismiss. And if that could be taken off of the plate of claims commissioner, those kinds of routine documents, and the claims commissioner could focus on more complicated decisions, it would make a huge difference. The motions practice is really overwhelming.
Yeah, understood. What would you say is the average time that a case pens before your commission, before a decision is reached one way or the other?
It depends on the case. We have the cases that get dismissed often get dismissed pretty quickly. How quickly will depend on how quickly we get something back from the Attorney General's office. They have been much more responsive in my term and since I came on board than they had been in the past. We had a big meeting at the very beginning of my term in which we kind of struck some agreements about, I would let them do their form letter if they would agree that they would file their appearance within a week and would have filed their position statement within 6 weeks. And, we sort of negotiated some things. And so they've been a lot quicker than they used to be, but we still have to wait for them to respond. And some attorneys are busier than others. So I would say a motion to dismiss case, we can get it out in 6 months, depending on the AG and how responsive they are. But a case that, needs to go to hearing, it depends on how long the parties want to take with their discovery process. Discovery is entirely up to them. I don't require any discovery, but I also, if they agree, don't limit their discovery, as long as they're in agreement about how much they want to do. So if they keep coming back and saying, hey, we want to do more discovery and we're in agreement, and I keep saying, okay, you can do more discovery, as long as both parties agree. So that it really depends on them in terms of how long it takes to get to a hearing.
Okay. All right. Thank you very much, Commissioner. And again, congratulations on your renomination.
Thank you.
Thank you, Representative Quinn. Next with questions is Senator Formica. Sir, the floor is yours.
Thank you, Mr. Chairman. Good morning. Good morning, everyone. Good morning, Madam Commissioner. How are you today?
I'm fine, thank you. How are you?
I'm sorry that I missed the first portion of your testimony that indicated that you've been under the weather a bit. So I hope that you're doing okay.
I am, thank you.
And moving forward. The questions on the amount of claims that we have, and I think I just heard you say there's 767 claims still pending and 276 that are at the legislature. So that's over 1,000 claims, with the oldest being 2015.
I think that was somewhat of a guess on my part.
Yeah.
I can get more accurate information later.
I may be familiar with the claim that goes back that far. My question is in terms of the process. The pending ones you talked about, the need for more staff to help manage probably some of those, are probably a relation of that. But the ones that have been released at the legislature, 276, could you tell me how they're released to the legislature? Does someone say to you, Commissioner, we need to release these claims and send them to the legislature, or is that a decision that you make? And if so, where do you send them, and how are they dealt with?
So those 276 claims are claims that are sent to the legislature because they've been pending at our office for longer than 2 years. And we are required to report those claims to the legislature each year. Any claim that's been pending for longer than 2 years, we're required to report to the legislature each year, unless we've received an extension of time from the parties, from the claimants. And frequently, the parties get frustrated because they wanted to extend the time, but they didn't inform us in time, and we've already sent it. But that being said, that's why they get reported. And the legislature, once they're reported, can extend the time and send it back to us, which is usually what happens, or they can decide the claim is yourselves. You can make an award, deny the claim, or grant permission to sue. Typically, the legislature doesn't do anything with the claim other than send it back. So we usually get them back again and go about our business deciding them.
So, thank you very much. It seems a complicated process that you have a clock that's ringing, and when it hits 2 years, you send it to the legislature. Do you send it to a particular committee? Do you send it to a particular member of the legislature? Do you send it to a particular office or agency?
The statute requires us to report it to the General Assembly generally, so we report it to the two clerk's offices, the House clerk and the Senate clerk. Typically, the leaders of the two chambers refer it to the Judiciary Committee, and that's typically the committee that decides what to do with it, and then they report the claims out to the floor as a resolution, and then the two chambers hear those resolutions.
So the judiciary must have some form of procedure, then, the Judiciary Committee, on these things, because they're coming in at a semi-regular basis, right? Every month there probably is a new 2-year thing. Does it happen once a year, or
no? Yeah, it's just once a year. We report it out at the beginning of each session.
I see. And then when judiciary, do they discuss this in the form of, like they would a regular bill that comes before judiciary?
Yes.
It's brought up to the committee and screened
they
and decided?
Yeah, they have a hearing. They usually have a claims day where they have a hearing and they hear all the claims. Anyone who wants to come and speak on any particular claim can do so.
Okay. And then it's after that, they're deciding whether to send back or not after the hearing, or is that, so everyone that gets referred to judiciary has a hearing at some point, and then whether they stay there to be adjudicated or sent back to you, and then does the clock start for another 2 years?
It depends on what the resolution says that sends them back to us. It usually gives us a deadline of a year, but it sometimes has been different than that.
Okay. And the public can come and testify when it goes before judiciary and all of that. Okay. And is this the high point? 767 pending and
well, within my knowledge, I can't I haven't, tried to pull annual reports back farther than 2016, but to my knowledge, from 2016 to now, this is the high point that I know of.
And thank you for that answer. And so if, and I don't remember whether you said you've asked the budget committee to give you that other staff member, or whether you just kind of brought it up today for the first time. But if you get the other staff member, how long to move through the 767? Do you ever want to get, not do you want to, but does it ever get to 0 or 10 or under 100? Or, I mean, is there always, just so I understand what process I'm looking at?
I can't imagine we'd ever get down to 10. I mean, there's always a bunch of cases that the parties are asking us to stay for some reason, or to, we're still working on it, or having settlement discussions or whatever. There's always a bunch of cases that aren't moving for reasons that don't have anything to do with us. So I think we're always going to have a docket, but it would be great to have, a body of cases that represents we are fully up to date on every case. You know what I mean? That a minute a case walks in the door, we're ready to work on it. That would be ideal. And I think yeah, go ahead.
I'm sorry to interrupt you. I was just going to say that the one new staff member that you may get, would that get us to that point? How long would it take to get to that point with this staff member? All things
well, I don't know.
being
It depends. I can't say for certain, because I don't know how good the staff person would be until they're there and I train them up and we see how they do. But I will tell you this, Senator, you don't know me. We did not work together. But one of the reasons I think that Governor Malloy originally appointed me was that there was an expectation that I would go in there and be a workhorse, because that was my reputation at the legislature before I was appointed. And I am a workhorse, and I was a workhorse before my health condition, but now I'm back to myself. And my plan had always been to go in there and do what I needed to do to get that office back to good operating form. And so I can't tell you how long it will take me, but I know that part of the reason I want this second term is so that I can go do what I originally planned to do, which is to get that office into order. And I don't know. I can't tell you how long it will take, but I know that I'm determined to do it.
And I'm sorry, I should know. Is it a 6-year term or a 4-year term? Or
It's 4.
4-year term. Thank you. Okay. Thank you. I think that gives me something to think about and to kind of make my decision. And then I appreciate your good work. I do hope you're feeling much better. And I thank the good chairman for his time this morning.
Thank you.
Thank you, Senator. Anyone else, any other members have questions for Commissioner Scott? Please raise your hand in the meeting. Going once. Okay, looks like we are done with the questions and remarks. Christy, I'd like to congratulate you on your reappointment to the Claims Commissioner position. But before you go, we ask one question of every nominee. Is there anything in your past that you believe might prove embarrassing to this committee, to the governor, or to the state of Connecticut?
There are lots of things that prove embarrassing to me personally, but not that I think would embarrass the state or the governor or any of you, hopefully. So no, my answer is no.
Thank you for being very clear on that. All right, saying that the answer is no, that officially concludes our public hearing of February 25th. We will wait a moment so that Wendy can switch gears here and get us into our meeting mode. And once we get the thumbs up from Wendy, we will move on to our meeting.
all set.
Okay, Wendy, you're getting good at this. This was like no downtime at all. Okay, I officially, bang bang, call the February 25th to 2021 meeting of the Executive and Legislative Nominations Committee to order. It is 11:06. Any remarks from my Senate co-chair before we move on, adhering to the agenda here?
Okay.
Seeing none, we can always come back to that if necessary. We'll move on to item number 3, which is resolutions for review. And I will make the motion to approve the House Joint Resolution reconfirming Christy Scott to serve as Claims Commissioner for a term ending June 30th of 2025. And I would entertain a second.
Second.
Seconded by Representative Godfrey. Any discussion? Seeing no discussion, will the clerk please call the roll?
Senator Duff,
Senator Duff votes yes.
didn't get you on camera, sir. Could you please say it again?
I'm here. I'm on
There you
camera.
go. Now I see you.
Okay, Senator Duff votes yes.
Representative Gresco.
Gresco votes yes.
Everyone's talking a little too quickly today. Would you say that again, sir?
My apologies. Representative Gresco votes yes.
Thank you. Senator Looney,
Senator Looney votes yes.
Representative Quinn.
Representative Quinn votes yes.
Thank you. Senator Kelly. Representative Kennedy.
Representative Kennedy votes yes.
Representative D'Agostino. Senator Fonfara. Senator Formica.
Formica votes no.
Representative Godfrey.
Representative Godfrey votes yes.
Senator Hartley. Senator Kushner. Senator Kushner votes yes. Senator Moore.
Senator Moore votes no.
Representative Perillo.
Perillo votes yes.
Representative Yacarino. Representative Vargas.
Representative Vargas votes yes.
Senator Summers. Senator Summers.
Sorry, my computer froze. I'm a yes.
Okay, I don't see you on camera. If you're
Oh,
having
sorry.
trouble, I can take it after. Okay,
Can you see me now?
yes,
Senator Summers votes yes.
thank you. That's the roll, sir.
Thank you, Wendy. As a reminder, we will keep the votes open for this until 2 o'clock this afternoon. And our next meeting is scheduled for a week from today, March 4th, where we will consider some Connecticut lottery nominations. So lastly, I will entertain a motion to adjourn the meeting.
Recess the meeting. Mr. Chairman.
Recess.
Yeah,
Joe.
let me rewind. I will, I will recess the meeting until 2 o'clock. Yeah, right out of my head. 2 seconds ago, I said that. Again, recessing the meeting until 2 o'clock. And thank you, everyone, for your participation. And look forward to seeing you next Thursday, the 4th.
Thank you, Mr. Chairman.
Thank you.
Thank you.
Have a great
Bye.
day, everybody.
All right, I'll be here till 2.
Have fun, Wendy.
All right, I'm going to start to make some texts and we'll see. Who do we need? We need D'Agostino. He's in a general law public hearing, but I'll text him. And then who else do we need? Vargas was there. Godfrey was there.
That was me talking to myself because I had it on mute. Senator Kelly, D'Agostino, Hartley, Yacarino.
Okay, got it. Thank you. Let me get on it.
Okay, all righty.
Wendy?
Yep, I'm here.
It's Dave. I was on, but I had to get off. I had an appointment.
Okay,
Just a one vote?
just one vote. Christy Scott
Yeah.
for claims
Yeah.
commissioner.
Definitely yes for Christie.
Okay,
Thank you so much.
thank you. Take
All right,
care.
bye. Bye.
um, she's A to Z's girlfriend, but she, by all accounts, did not do a ton.
Would you like to vote, sir?
Yes.
Okay. Christy Scott for Claims Commissioner.
Yes. Or Senator Kelly votes yes.
Thank you so much.
You bet. Thank you.
Have a great day.
You too.
Bye
Bye.
now. writing down for a second.
Oh, no, I'm sorry. My apologies. So I missed everything. I'm sorry. Did
That's
I?
okay.
So yeah, who do we hear today, Wendy?
Christy Scott for Claims Commissioner, and that's it.
Oh, only one. Okay.
Mhm.
Yeah, no, I know. Apologies, I had transportation on a probes. Anyhow, and we voted?
Yes,
Okay. Is this a joint or what?
it's joint, yes.
Okay. All right. So I'm what would like to be recorded in the affirmative, Madam Clerk.
You got it.
Thank you.
Okay.
Be well.
You too.
Have a good
Bye-bye.
one. Bye, Wendy.
See ya. you hear me, Representative?
Can you hear me?
Ken,
All right, there we go.
I saw you connecting, just kind of
Yeah,
connecting.
love the audio.
We have just one vote, Christy Scott for Claims Commissioner.
Agostino votes yes.
Thank you. That's it.
Are you going to leave this open for a little bit?
I have to leave it open until 2 o'clock because that's what they said. So
All right, if
it's
you see me join in, I'm just testing the Zoom thing, just ignore me.
oh, okay.
Okay.
Yeah, since they said 2, it has to stay on.
All right, thank you.
Suppose
Just
someone
ignore
else-
me if you see me jump in and out.
No worries.
Thanks.
Yep. Do you still want me to send your to both emails? Let's test your unmute.
Yeah, sorry. What'd you ask me?
Do you want me to still send to both emails?
Just the state one is fine.
Okay.
Yep. Thank
You
you.
got it.
Wendy, are you there?